Good morning, Mark Scheifmeyer, the city's hearing examiner. I've been asked to convene a public hearing on behalf of the appellant, CIS Corporate Identification Solutions, Circle K, appealing the city's decision relative to a monument sign for a proposed project at the intersection of Yelm Avenue and Colean Street in the city. In advance, that's an appeal bearing the date July 9, 2025. In response to that, the city provided a written response, which I've also received, incorporating some of the application materials together with the city's narrative and briefing response. So I have received all of those materials in advance of today's hearing. I have reviewed all of them in advance. I'm also familiar with the site. It's an area of where there has been a significant amount of development over the past few years, and that development has caused me to inspect that area multiple times. So I am familiar, although I'm not a resident of Yelm, I am familiar with the site in general, as well as specifically. So today's hearing is for the purpose of considering the Circle K's appeal. Appeal hearings have two different unusual qualities. One, it's not always clear what extent, if any, there are factual disputes that require testimony. And then secondly, if there is a preferred order of presentation. As to that question, it is the appellant's burden on an appeal to demonstrate that the city's action was arbitrary and capricious. And so typically the party with the burden is often asked to present first. However, in city matters, it is oftentimes more convenient or more educational for the city to present first to sort of lay out the circumstances. And then that provides a platform for the appellant to explain its appeal. I suspect that the parties have not really talked about this in advance of today's hearing. And so haven't really thought about it much, or perhaps don't have a particular thought about it. Let me begin with Mr. DeHaze. Mr. DeHaze, were you envisioning the presenting of any additional factual testimony, or were you relying upon the information found in your appeal statement?
No additional information from us other than pointing out, relying on our submittal document that we sent in, plus some items that in staff's report, but nothing outside of those two reports.
So you're not anticipating any testimony then? Is the city anticipating testimony, or simply a follow-up argument to its narrative, to its response?
When we communicated with Mr. DeHaze and staff, we were kind of under the impression that that they would go first and then we would go second.
Okay.
Really have a preference?
That answers half of my question. The other half is whether you envisioned any testimony over and above what's found in your written response, or whether we have a situation where the parties are simply wanting to provide argument rather than additional testimony.
We don't have anything outside of the staff report.
That is what I had anticipated from what I had received, that both sides had well stated their positions in their materials, and that there wasn't likely to be any additional testimony. So I'll work on that notion, that I'm not here to receive testimony, but rather to hear or receive argument. And keeping in mind that I have again received and reviewed all of the parties' materials presented to date. Not that prevents anybody from repeating those materials, but just to be aware that I am familiar with them. With all of that in mind, let's begin then with Circle K. Mr. DeHaze, if you would summarize the appellant's positions, why it believes its interpretation of city code is the more appropriate one, and why its requested relief should be granted.
Yeah, and thank you for the time this morning. And I think this would boil down to just a difference in interpretation of what is being proposed at this development and how that development would fit into kind of the existing framework of the zoning code. In other words, the zoning code could have been written without this type of development in mind when it was written. So specifically, there will be two separate structures on this site that will support two different operations with two different products and product types. So if I'm a customer, I do not need to necessarily visit both structures. I can visit one or the other, or both for that matter. But the customer journey is individual and it is separate. That is very unique that you have two different customer journeys all within, call it one parcel. Now, as such, we've taken the position that then would be deemed a multi-building complex, because you do have two distinct different structures serving two different purposes and really having two different products. The focus is on two different sales. This staff has taken the position that our definition, or how we're interpreting we're interpreting these structures as not qualifying as a building per se. However, I will point out that in staff's report, I'm reading from the bottom of page 2 of their report, under the definitions paragraph, the definition of building in the Yelm Municipal Code 18.02 refers to structure. Now, if I then refer to refer to the two structures on the property, I think I am meeting the definition of building as it is stated in the code. Obviously, that paragraph goes on to define structure as it pertains to flood damage, which really isn't relevant here. It's unrelated. All that being said, I think it's fair to make the assumption that this code, when it was written, really didn't have this kind of development in mind when it was written. So for those reasons, when we look at this development with two distinctly different structures on it, with two distinctly different customer journeys, we do think it does meet the language of a multi-building complex, which by the code would then allow a second monument sign for the entry off of Killian. And again, I think it's also important to point out is we're not asking for anything above and beyond what zoning code would allow under this definition, meaning we're not trying to get a third and fourth sign or any of that kind of stuff. We're not trying to exceed the zoning code in any way. So anyway, that is our position.
Okay, thank you. Mr. DeHaze, not many questions or thoughts in response or points in response, other than in examining the proposed signage, the two monument signs do the same thing. Do you agree that they're both announcing the brand and they're announcing the fuel price? They're not announcing two different things, but simply the same thing at two locations.
Concur. However, one cannot see both at the same time.
Understood.
From if you're on Killian, which is again an entry point.
Okay, thank you.
Mm-hmm.
So the record should reflect that the city is here through a number of staff. Mr. Collar is the party who had prepared the city's response. He is present along with several other staff members. So, Mr. Collar, how does the city respond?
Thank you, Mr. Scheidmeyer. The city would like to respectfully disagree with Mr. Hayes. We believe that the sign code was written exactly for this purpose. Circle K is not the first gas station on a corner in Yelm. And since the staff report was submitted, I apologize. I said we weren't gonna add anything. I would like to add one thing. Since the staff report was submitted, the appellant received approval for 2 pricing signs on the canopy. One facing Killian and one facing Yelm Avenue. Well, the definition of structure, definition of building refers to structure in the Yelm Municipal Code. In relation to flood damage, it also says it's a walled and roofed building under that definition. The argument that, you know, there's 2 different journeys or 2 different use categories really doesn't apply in this situation. Because the sign code goes on to explain that if there is a multiple occupancy building, which could house several businesses that serve completely different use categories, that multi occupancy building would still be limited to 1 sign. So the bottom line is city staff believe the applicant is misapplying the term multi-building as it was intended. City staff interpret multi-building to mean occupied building.
Thank you, Mr. Following up on one of your comments about this not being the first convenience store gas station, have there been building permits sought post this ordinance of of convenience store fueling stations at intersections?
I'll defer to Chris.
Chris Vaccaro, building official for the city of Yelm.
So in response to the question, in driving through the city, I note that there are convenience stores down the street. There's the Safeway. There's multiple places where there is both fuel and convenience food supplies. None of them either were done post this ordinance or are at an intersection.
We have several that are at an intersection. We have the Exxon Chevron that's on 507 and the what's that?
I think Creek
Creek
Street.
Creek Street.
Was that before or after the sign code? I don't know.
Yeah, that's a good question because I don't have earlier versions of the sign code, and I don't believe the sign code was amended or changed in any way. So the AMPM and the Chevron Exxon both, I believe, were approved under this sign code, and both having 1 monument sign despite being a corner fueling station with the convenience market and fuel canopy.
All right. So in answer to my question, I'm paraphrasing, so you tell me if I'm running on the same tracks as you are, that in instances in which this particular version of the sign code has been in play, its interpretation has been consistent with the city's current position on the Circle K.
Correct. I have not seen any amendments to the code in that time.
Okay. Do you happen to know in those instances where there are additional signs were sought and denied, or simply one was sought? Do you know anything more about those other instances?
One was sought, yeah, there wasn't multi-signage.
Okay.
Sought out.
And whether one was only sought because of their interpretation or whatever they may have been told, or whatever else, you don't know the circumstances as to why.
I can't speak for their intent, no.
Okay. Has the city encountered any other situations that it can recall in which a second type of structure came into play in sign interpretation? And if so, in what instance and how was it dealt with?
Shell gas station on 103rd in Yelm, they have a car wash.
Okay.
So they have 2 monument signs because there were 2 structures on site, the car wash and the convenience store.
Okay, so the shell gas was allowed a second sign because the car wash was regarded as a building. And therefore it was granted that second sign. And it was regarded as a building because why?
Per the definition, a walled-in structure.
Okay. All right. Thank you. Anything else, Mr. Caller?
No, not right now.
Okay. And, Mr. DeHaze, any rebuttal?
A couple things. One, that shell is a very interesting. I'll call it a precedent. I think that's a very similar situation as what we have here, meaning a customer can go onto a site, can get a car wash or get groceries, but does not necessarily need to visit both. So two completely different experiences on the same property. That property was allowed a second monument sign. I think that is a very almost an exact duplicate of what we're being asked for here. So it's two different experiences in two different structures. Very similar. Only difference is car wash versus fuel, but they're just distinctly different. And then staff earlier talked about brought up the idea of multi-occupancy section, some portion of the code talking about a multi-occupancy. That is not what we're talking about here. That is a different section of the code. We are specifically talking about 18.62.080 paragraph D of the code, which is a corner parcel with 2 street frontages and entrances on both streets with a multi-building complex may place a 2 or 3 faces monument sign at the corner of a property and a monument sign at each entrance. That is the section of the code that is under appeal. The multi-occupancy is unrelated and not part of this.
Okay, thank you. This is proving to be surprisingly difficult, more difficult than I had first thought. The information from the city of 2 other convenience stores where only 1 sign was allowed was strongly supporting its arguments, only to have the Shell store throw a wrench in the works because it defeats part of the city's argument found in its briefing, which has to do with occupancy. So the city was arguing strenuously in its written materials that occupancy played a key role, but obviously that doesn't apply to the car wash at the Shell station. So I'm left with this sort of much more complex set of fact patterns than I had anticipated. But when it all comes down to it, what is compelling is that 2 things. One, that it is the applicant's burden in this instance to demonstrate that the city's position is clearly erroneous or arbitrary and capricious, coupled with the fact that I am directed both generally and specifically to be deferential to the city's interpretation of its own regulations, so that to the extent that there's ambiguity and there are multiple interpretations, that the interpretation made by city staff, to the extent it is shown to be consistent, is to be given deference. Deference is not slavish acceptance, but it is respect to the extent that that interpretation is a reasonable one. And so to overcome the city's interpretation, it must be demonstrated, 1, it is either inconsistent, or 2, it is unreasonable. It is almost inconsistent. It is very close to being inconsistent as applied to the Shell station, but it is not exactly inconsistent. And it is not unreasonable. In fact, it is a commonsensical interpretation of the term building. I should say what that interpretation is, which is a walled structure. And so it is not an occupied structure, but it is a walled structure. Now, for a later day, are some interesting intersecting points of that interpretation as to various other types of walled structures that might be claimed to be buildings sufficient for additional signage. I will jump off that bridge when we get to it, but for the time being, the city's interpretation is again reasonable and has not been demonstrated to have been arbitrarily applied. A close call, but not arbitrarily applied. A long way of saying I'm going to deny the appeal. I do find that the city's interpretation is an acceptable one, that it is well founded and appropriate. And based upon that, I'll conclude that the appellant has not met its burden. This is a very close call, closer than I had anticipated when I came into the room today. But I do find comfortably that the city's interpretation is an appropriate one, and I'm going to go ahead and therefore deny the appeal. I'm going to reduce that, not so much a brief set of findings, because the findings are undisputed in this instance, and rather the more important thing is my conclusions of law, which support my decision. I will attend to those ASAP. I will reduce those to writing so that if the appellant wishes to further appeal that as a LUPA Land Use Petition Act decision to the Thurston County Superior Court, that it will have my decision in writing promptly in order to do so. I would remind the parties again that further appeal would be to the Thurston County Superior Court pursuant to LUPA, which requires certain time and other standards being met. It's not my job to explain all those, but simply I wish to remind the parties of that process. So with that, I do appreciate the articulate points made by both parties. It's a very interesting question with not nearly as an easy answer as I had anticipated. But again, I am finding that the standard for appeal has not been satisfied and is therefore being denied. I'll reduce that to writing as quickly as I can. And with that, we're adjourned. Thank you.